Good morning, everyone. My name's Helen McIntosh, and I'm the president of the South East London Chamber of Commerce. We're delighted to be having an update because we had a webinar. I think it was it at the beginning of the year, David?
Yeah, I think yes. I've done two, I think, so far since COVID on this. Yeah.
Okay, so yes, so we're going to have an update on commercial rent arrears, and we're going to hear from the expert David Hacker, who is a partner at Thackray Williams. And over to you, David. And if I could ask everyone to put themselves on mute till we get to the questions at the end, which we'll take right at the end when you put your little yellow electronic hand up. Over to you, David.
Okay, thanks, Helen. Just sort of introduce one. Actually, I know some of you well on this call, but for those of you who don't, as I say, my name's David Hacker. I'm a partner at Thackray Williams. We are based in London, Bromley, and Kent. I specialise in commercial property disputes principally, and so I'll talk to you today about all these subjects of rent arrears. I've called it commercial rent arrears in the post-COVID world because when we were subject to COVID, there were a lot of restrictions in place in relation to what landlords do in relation to rent arrears. So I'm just going to sort of talk you through that this morning. You know what the options are now. Certainly, if you are a landlord, it's spoiler alert. It's a lot better for you now than it was a couple of years ago. Yeah, but the next slide, please, Charlie. This is just three partners here who myself and Yildiz work very closely together in relation to commercial property, and Andrew there is our senior partner. He deals principally with residential property disputes, but yeah, the three of us work very closely together. So that's at least part of our team. Yeah, next slide, please. Yeah, so as I said, the COVID pandemic put a tremendous strain on landlords and tenants of businesses, and effectively for some 2 years there was a moratorium really on actions that landlords could take in relation to problems with rent that tenants had, and this was brought in literally as we went into lockdown in March 2020 to basically prevent potential mass evictions of commercial tenants. The government put this moratorium in place initially for 3 months, and then it was extended and extended, and lasts for about 2 years. Yeah, next slide, please, Charlie. So the current position, from my personal, certainly from my personal experiences, and I'm sure for yours as well, life continues to be tough for lots of businesses all across the various sectors, from retail, hospitality, entertainment, professional services. All of us, for various reasons, are having a tough time. But as I say, this morning I'm concentrating principally on what landlords can do if they have tenants who are in rent arrears. Yeah, next slide, please, Charlie. Yeah, just touch. I mentioned it a couple of minutes ago. Just touch on where we were during COVID. Basically, landlords couldn't really take any action. They couldn't forfeit leases. They couldn't take possession of goods or issue winding up petitions in relation to companies, or bankruptcies in relation to individuals. So there was a real strain, strain on relations during that time. I mean, although the action that could be taken by landlords was very, very limited during the COVID period, actually, I was incredibly busy dealing with landlords and tenants because there was lots of negotiations that were going on, really, basically, between them as to what each could do to help each other. So it was, although legal action was basically on hold, I was incredibly busy. Now, I was due to do this webinar a couple of months ago, and actually since that had to be postponed, and since then there's been a change in the law. But from the end of March this year to the end of September, the government put in place an arbitration scheme for rent arrears that had accrued during COVID to prevent landlords forfeiting leases for those specific arrears. The rules of it in relation to it were quite complicated, technical, and they related to rent arrears that grew up during different dates. The good news from a landlord's perspective is those rules have gone. In fact, in that 6-month period, I never had to take recourse to their arbitration procedures at all. So that's all gone. So we are now back to where we were pre-COVID. So that's 2.5, 3 years ago. So what I'll do now is just take you through that and show you what the options are. Yeah, next slide, please, Charlie. So the main ones that we use are forfeiture, commercial rent arrears recovery, called CRAR, drawing down on a rent deposit, calling on guarantors or former tenants or guarantors of former tenants. Yeah, next slide, please, Charlie. Requiring perhaps a subtenant to pay rent to a head landlord direct, taking court action, entering into some sort of payment agreement, renegotiating the lease itself, exercising a break clause, or landlords taking a surrender. So those are sort of the headlines, and I'll explain each in a bit more detail. But those were certainly the ones that I've used over the years. And the next, if you take me to the next slide, please, Charlie. My recent experience since the restrictions were lifted back in March is that landlords have continued to be very understanding. I think they understand that tenants are having difficulties, possibly different difficulties now since the COVID restrictions have been released, but difficulties continue. A number of landlords have been prepared to agree to rent deferrals, and the big one I think for me is that forfeiture of leases is back on the rise. I've probably done more forfeiture in the last 6 months than in the 5 years prior to that. So for the stubborn tenants, I think, who really couldn't come to any sort of arrangement with their landlord, or where relations had broken down, forfeiture, I've certainly my experience on the rise. From a tenant's perspective, the big thing I think I've noticed when it's coming to looking at lease renewals is that tenants are looking for shorter leases. They're looking for break clauses. They're looking for turnover rents. So they're very much looking, I think, flexibility, because we just don't know where the world is headed, and so it's flexibility, I think, is still is the thing for the tenants. Yeah, next slide, please, Charlie. So forfeiture. What is forfeiture? Forfeiture is basically a landlord can re-enter commercial premises as long as the lease allows, and change the locks and retake possession, and the lease comes to an end. So forfeiture is really quick. It's very effective. I mean, if I were contacted today by a landlord who wanted to forfeit a lease for rent arrears, I might even be able to do it today. I could certainly be able to do it tomorrow. So it's really quick. And as I say, very effective. Yeah, next slide, please, Charlie. Once the landlord's got possession, that's kind of it up to a point. The landlord has the property back. Landlord has to take over responsibility for all the outgoings on the property from then, and may have to deal with tenants, customers, and creditors. I mean, I've had over the years, where we forfeit dry cleaners, and suddenly you find you've got all these customers who are ringing me because my name, if I do the forfeiture, tends to get posted on the door. I have all these customers ringing me, wanting to come and pick up their dry cleaning. So there can be quite a lot of, there can be a lot of fallout from that, but as I say, really effective. Tenant can apply for what's called relief from forfeiture. What that means is the tenant can apply to the county court and ask to get their lease back, and the courts may well grant them that relief, but only if they pay all the rent and they pay all of the costs. And as I say, terms for relief from forfeiture are generally quite strict. So I've certain forfeitures I've dealt with recently for landlords. I've not had any applications for relief from forfeiture, although some have been threatened. I dealt with one tenant who was subject to a forfeiture, and we applied for relief, we got it, but it was very expensive because of the legal costs they had to pay. So yeah, forfeiture, quick, cheap, and very effective. Yeah, next slide, please, John. Yeah, next on mine is commercial rent arrears recovery, commonly known as CRA. This is something that, to be honest, I don't really use that much, but it may be of interest to certain landlords. There are what it basically involves is enforcement agents going to the tenant's commercial premises and taking possession of goods to sell. Now, what they usually do is enter into an agreement effectively. They don't take everything then and there, because usually not able to do that for various reasons. They give the tenant a chance to pay the rent, and if the tenant doesn't then pay the rent, then you can just take me to the next slide, Charlie. Then, as I've said there, the landlords can take control of the tenant's goods and sell them at a public auction, and then use any monies raised to pay their rent. Well, as I say, not something that I've used recently, but it's certainly an option. I think for the right type of business. Yeah, next slide, please, Charlie. Yeah, this is just a bit more detail about how CRA operates. But you need an enforcement agent, and we do instruct those on behalf of clients, and they have to serve certain notices and on the tenant. take possession of the goods, and then generally give the tenant time to pay the rent, and failing that, go back in and sell. Yeah, next slide, please, chart. Just a bit more detail there on what type of goods and where they are. As you said, there are quite a lot of restrictions. You can't use personal items. You can't use things obviously that don't actually belong to the tenant, and you can't use some of their tools of their trades. It's quite limited. But just the thing particularly to be aware of, I think, is that if you elect to use craft rather than forfeit that, then that can waive the right to forfeit to the rent that the particular rent that you're going for. So you elect to go one or another way. Okay, next slide, please, John. Yeah, collecting rent from an under tenant if there is one. So if you've let the property to a tenant who's then sublet it, and you don't have any direct contractual relationship with that under tenant, because your tenant pays you their rent, and then they collect rent from their under tenant. But what you can do is survey a notice requiring the under tenant to pay you, the head landlord, directly. So this is something that I've used where, for whatever reason, your tenant is collecting rent from that subtenant, but deciding not to pay it to you as a landlord. So they pay rent to you directly, and they can offset whatever is owed to their landlord from the rent that they're paying you as the head landlord. So that can be possibly fairly limited in some ways, but can be useful where there is an under tenant. And so there's a little bit of just the detail on the slide there as to the option, the procedural requirements in relation to that. Yeah, next slide, please. Another option, lots of landlords take deposits for on the rent, and certainly during COVID, this was something that I've found that landlords who had taken rent deposits were using those to at least sort of mitigate some of the arrears that had arisen. So what happens is you take a deposit generally at the outset of the lease, and then if the tenant fails to pay the rent, you can draw down on that deposit to pay some or all of that rent. Generally, in a rent deposit agreement, there's a requirement then for the tenant to replenish the deposit. If there is insufficient money in the deposit and the tenant still owes you rent, you can still forfeit the lease if that's what you wanted to do. So that's certainly very useful. And again, sometimes landlords may take guarantees. If you are let into a company, you may want to take a personal guarantee, say from a director or a couple of the directors of the company, and you can certainly demand rent from them personally if the company landlord isn't paying their rent. Whether they've got the means to pay is not a question, of course, but there is that option. Yeah, next slide, please, John. Also, an option to claim rent from a former tenant or a former guarantor of a lease. That is under the Landlord and Tenant Covenants Act 1995. There are when a tenant, so this might occur where a tenant takes a lease and they sign a lease a few years down the line to somebody else, and they probably have no connection with that person at all. But although they would be released from covenants on assignment, they are not necessarily released from an obligation to pay rent in an arrears situation. If you just take to the next slide, Charlie. There are some. There's a. What's important here is if you are going to claim rent against a former tenant or guarantor of the former tenant, there's a 6-month time limit to do that. So you can't just let years worth of arrears build up and then claim all those against the former tenant. You'd be restricted to the last 6 months worth of rent. So that's quite an important time limit to note. You have to issue, there's a statutory notice that has to be completed. And if you just take me to the next slide, Charlie. Yeah, it's important that all of that form is correctly completed. It's not a difficult form, but it does need to be completed correctly, as otherwise that can invalidate it. And just one thing to note: if you are calling on a former tenant or a guarantor, is that the former tenant, if they pay, can ask for what's called an overriding lease. What that basically means is that they're entitled to a lease that sort of sits between you as the landlord and the tenant's lease, because they've been paying the rent, then they're entitled to an overriding lease, which is sits between you, so that they can, they've got obligations to pay rent to you, so they want to have some control over that as well. So they can apply for that. So from the landlord's perspective, what you could find is that you haven't just demanded rent from the former tenant. You kind of got the former tenant back as a current tenant. So just something to be aware of. Yeah, next slide, please, John. The other thing that you could do is take sort of what I call legal action. So you could serve a statutory demand on a company or an individual. A statutory demand is the first step towards making somebody bankrupt or putting a company into insolvency. You serve it, again, it's a statutory notice. You serve it on the tenant, requiring them to pay the rent, and if they don't pay it within 21 days, then you can take it to the next stage of applying for them to be made bankrupt, or for the company to be wound up. Can be really effective, and that was something else that was put on hold during COVID. Companies do not want to be threatened with winding up positions, because that can happen. Just the threat of it can be absolutely disastrous. So can be very effective. But if you have to then go to the expense of taking bankruptcy or insolvency proceedings, then it starts to get expensive, because then you're responsible for winding up a company, and that's there's quite a lot of work that may be involved in that. But certainly the threat of it, is very, very effective. Alternatively, you could, I have had this happen in the past, but rather than a landlord wanting to forfeit a lease, you issue a money claim in the county court. And you could do that, I had a particular landlord client for some reason did it every quarter when the tenant wasn't paying rent. The landlord didn't want to forfeit, didn't want to let them out, wanted to secure the debt, so was taking county court proceedings. You issue a claim online, assuming the tenant doesn't defend it, and then 14 days later you can apply for a county court judgment against them. And once you've got a county court judgment, then that opens the court's enforcement procedures to you. Now, whether the CCJ in those circumstances would have much worth, open to question, because you've got all through that, the tenant still hasn't paid, whether the county courts, bailiffs and what have you will be able to extract the money is very much open to question, but it's an option. Okay, next slide, please, Charlie. Just touch on some of the other options that there were. A lot of these were particularly relevant during COVID. You might agree to temporary change to lease terms to allow rent deferrals, change the payment schedule, moving rent from quarterly to monthly payments, perhaps. We might agree to a permanent change to the lease, lower rent possibly. You might be prepared to accept a surrender. I was involved in a few lease surrenders, actually, both during and post COVID, where for various reasons it suited both landlord and tenant to actually surrender the lease, so that the landlord gets the lease back and can re-let. And if there's a break clause in the lease, then that might be an option for landlords or tenants, if there is one, rather than take a surrender, exercise a break. So just some other options, really, if you are, if you're talking to your tenant, if relations have broken down or the tenant's burying their head, then the other options I've talked about are probably the most appropriate. Next slide, please. So, what would I recommend? Well, lawyers' answer, it does depend on circumstances, but as I think I've said already, forfeiture is the most effective tool, and that I would say is my go-to for landlord clients with problem tenants. As I say, I found it very, very effective. I rarely use the other methods of enforcement because I think when you talk through them with landlords, they tend to say, well, problem tenant, go for forfeiture. I mentioned there just surrender and break clauses being quite popular. Next slide, please, Charlie. So really, I've talked all about the landlord. If there are any sort of commercial tenants online, or then who want advice, and I certainly advise both. The options now are somewhat limited because the landlord's powers are fully back, but you've got to try and talk to the landlord. Explain the circumstances. Try to reach some sort of agreement. If that fails, just keep trying. But do be aware that if you are a tenant and you are in rent arrears, then you are liable to forfeiture pretty much at any time. And sorry, from my screen there. So just to be aware of that, you do really need to try to come to some sort of agreement with your landlord to avoid forfeiture. And if you are like if it's really got that bad, then then landlord might be willing to accept a surrender. So you need do what you can to talk. Okay, next slide. I think I'm pretty much communication. That's really sort of the name of the game, I think, for landlords and tenants. I mean that's sort of a whistle stop really through the options principally for landlords, as to what they can do. But yeah, things are firmly back in the landlord's remit now for action. So yeah, happy to take any questions from anyone on anything.
Lovely. Thank you very much, David. Charlie, can you take the slides down so we can see everyone, and if people can put their cameras on? Lovely.
Oh, I see Paul's there. Hi, Paul.
Super. Lovely. Be lovely if we can see you. Still there, Nigel? We caught him out. No.
I know Penny had it, because Penny emailed me yesterday. I know Penny, you had a question, didn't you?
Yeah, sorry, I'm a bit technically challenged, so I'm just trying to put my hand up. So yeah, my first question was, I'm currently dealing with McCall's in administration, and obviously Pricewaterhouse have come in and said that they're picking up any rent arrears from the 9th of May, but we've got stuff going back prior to the 9th of May, and I just wondered legally where we stand in being able to get that money back. Well,
I'm also dealing with for a client on another McCall's, and we'll have to see what the administrators do. I mean, I don't know where any of the other options that I've talked about. They're probably, if there was a rent deposit, I imagine that's probably been exhausted. Don't know whether there's any guarantors, or any. If there was a former tenant, that might be an option. I'd have to look into it. But the pre-administration arrears could be an issue in recovery, to be honest, if the money's not there.
Okay, so basically you've mentioned previous tenants. So
yeah,
if the lease was assigned for the remaining term of that lease, and then a new lease with the new tenant is negotiated 2, 5, whatever years down the line, does that mean that the former tenant, you can't go back to the former tenant because
no, it's only the tenant, only the former tenant under the current lease.
Okay, so if that current lease is expired,
so if you've got a 10-year, say a 10-year lease, and 5 years ago it was assigned and it's still running, then there's a former tenant there that you might be able to attack. Okay. But
and
one thing though that I would say is because of the administration, that might affect the right to go against the former tenants as well, because there's an insolvency process in place now. So that might be, but I mean, if you want, I'm happy to look at it if you need something to a bit more detail.
Thank you.
But yeah, it does complicate things with the administration of McCall's. I mean, certainly for the client that I'm dealing with, who we've got I think actually there was a sufficient deposit that we drew down to deal with the pre-administration arrears, and then the administrators obviously paying the rent now, and now they want to renegotiate. Well, now they've offered, they want to renegotiate the lease and basically offer about 50% of the current rent. So.
Okay, and my last question, sorry, is about forfeiture. So does the forfeiture process have to be done through a solicitor, or can it be done individually?
Yeah, I mean, you could. I think you can do it individually. I mean, I use certificated bailiffs to do all of my forfeitures. I think that the bailiffs, in my experience, they tend to like to have a solicitor deal with it because it provides some protection for them to make sure that all the necessary paperwork's in place, and that there is a right to forfeit and what have you. Because if there were no right to forfeit for whatever reason, then the landlord could find themselves on the end of an unlawful forfeiture, which could be really expensive for the landlord if they forfeit unlawfully. If they basically close down the tenant's business. I have had that in the past. So certainly my experience, all the bailiffs I use, they like to have a solicitor basically just confirm that the right to forfeit is there.
Okay, all right, that's brilliant. Thank you.
Okay. Yeah.
Paul Baker now.
Oh yeah, morning,
Hi,
David.
Paul. Yeah, hi, Paul.
Yeah, I suppose really it's not a direct question. I suppose it's more me sort of checking my understanding, perhaps, of the. I'm particularly interested in the commercial rent arrears recovery option.
Yeah.
Now, I assume the from what I understand, listening to you, is the difference between that and say forfeiting the lease is under CRAR. I wouldn't take on all the creditors of the business. But I suppose the other thing to consider is it's only worth doing if the business has got stock to sell, and also the fact that the business owns that stock and it isn't still under credit terms.
Exactly.
Plus you don't get your property back. You don't get the tenant out. You just get your rent back.
You just get your rent. I mean, you know, to be honest, I've rarely used CRAR. I mean, actually, it has to be dealt with by enforcement agents, so sometimes that doesn't come by solicitors anyway. But yeah, for all of those reasons that you mentioned, it's quite you know, it's quite limited. So you know, they may well, you know, you may well have, you know, tenants where it might be appropriate, but a lot of the ones that, you know, that I've dealt with, it hasn't really been, you know, I haven't had any goods, you know, professional services, you know, there's nothing there. You can't really take their tools of their trade, or you don't want to, because, you know, it's, you know, you've got to try and sell some of this stuff. So yeah, but it's certainly an option.
No, okay, so yeah.
Excellent. Do I have any more questions?
So I mean, I know most of you on the call, so we you know, we you know, if there's specifics on stuff, then give me a call, drop me an email. You know, Penny, you know, happy to have a look at that lease on the coals for you. Yeah, I mean, you know where I am, and so, you know, just pick up the phone.
Thank you very much, David. That was been absolutely excellent. And I'm going to be really cheeky and say, can we book you in for 2023 in the student?
You may.
Thank you very
much. Hopefully, there won't be any more major changes. I think it's going to be. Well, I think, you know, just sort of, it's obviously going to be, you know, a very, you know, interesting next 6-12 months. I mean, see what other people's experiences. So yeah, it's going to be tough.
Thank you very much.
Okay.
And can I just say that to everyone that this will be going up on our website, and, you know, we'll let you know. And as I say, David's given the invitation for everyone to contact him. And if you need any details, you know, just email the office and Charlie will help out. So I'd like to thank you very much, David.
Pleasure.
Really interesting morning. Thank you.
Okay, good to see you all.
Thank you.
Okay.
David.
Bye.